Welcome to Do It for the Case Law for Tuesday, July 28th, 2026. Visit doitforthecaselaw.com to listen to more in-depth, per-case reporting. Today we are covering 87 federal appellate decisions across 5 reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. Today I have 30 criminal justice opinions across 7 circuits. In terms of outcomes, 26 were affirmed, 2 were dismissed, 1 was denied, and 3 resulted in reversals or remands. We will start with the mixed results before moving through the affirmances circuit by circuit. Over in the 8th Circuit, the court reversed and remanded Benjamin Strickland case. The district court had denied his motion to dismiss a charge for possessing a firearm as a drug user under Section 922 of Title 18. The appellate court found that while the statute is not facially vague regarding methamphetamine users, the government failed to show that Strickland's specific conduct fits within the nation historical tradition of firearm regulation under the Bruin framework. Because the record did not establish he posed a credible threat or acted like someone mentally ill and dangerous, the conviction cannot stand as written. Moving to the 9th Circuit, Jonathan Lopez received a remand on his sentence. He pleaded guilty to possessing a firearm as a prohibited person. The district court had applied a 2-level sentencing enhancement for being a career offender based on prior California convictions for assault with a deadly weapon. The 9th Circuit held that those prior offenses do not categorically qualify as crimes of violence under the guidelines because they can be committed with reckless mens rea, which falls short of the intentional or knowing force required by Supreme Court precedent in Borden. The case goes back for resentencing without that enhancement. In the 4th Circuit, Abdullah Khalil Michel had a split outcome. He pleaded guilty to conspiracy to commit Hobbs Act robbery and using firearms during a crime of violence. The court enforced his appellate waiver, dismissing challenges to his procedural and substantive reasonableness on appeal. However, it affirmed his convictions outside the waiver scope, rejecting his argument that Hobbs Act robbery is no longer a valid predicate crime of violence under federal law, citing binding circuit precedent. Now let's look at the affirmances, starting with the 10th Circuit. In United States v. Meyer, the court upheld a 420-month sentence for distributing illegal images of minors. The defense argued the district court erred by applying the production cross-reference to calculate his offense level rather than the distribution guideline. The appellate court found no plain error because Meyer failed to show factual support that he distributed images to minors with the intent to entice them, a key element for the higher production enhancement. Also in the 10th Circuit, Terry v. Drummond affirmed the denial of a preliminary injunction against Oklahoma riot statute. Plaintiffs claimed the law was unconstitutionally overbroad and vague. The court resolved ambiguities by certifying questions to the state highest court, which clarified that the statute requires willfulness and common intent among 3 or more persons to use violence. With that construction, the federal court found no substantial likelihood of success on the constitutional challenges. In United States v. Appellate, the Second Amendment challenge to the felon in possession statute was rejected as foreclosed by binding precedent following the Supreme Court decision in Bruin. Similarly, in United States v. Mims, the court affirmed a sentencing enhancement for possessing a firearm in connection with another felony. The gun was stolen during a burglary, but the court found it facilitated the crime by enabling its completion or escape. Preston Campbell's conviction for assaulting a federal officer with a deadly weapon was also affirmed. The court held he waived his challenge to the admission of prior convictions for impeachment because he did not testify at trial, and any error regarding police dog injury testimony was harmless. Turning to the 11th Circuit, Harlan DeCosta's compassionate release was affirmed. The district court considered sentencing factors before determining if extraordinary and compelling reasons existed for release. The appellate court found no error in that sequence or in weighing his role as a fraud factory leader and prior armed robbery history against any request for early release. Kenneth Burke's sentence after one conviction was vacated on collateral review was also affirmed, with counsel withdrawing under Anders after finding no meritorious issues. In the 4th Circuit, we have several affirmances. Gary Rocky Jones' convictions for child exploitation and enticement were upheld. The court rejected claims that proceeding with trial in his absence or denying his request for self-representation violated his Sixth Amendment rights, citing his disruptive behavior and threats toward the judge. Robert Hoffman, Servando Mendoza, George Hamer, Jose Miguel Tapia, and Sarah Berry all had their sentences or motions denied on appeal. In Tapia's case, the court emphasized that he failed to exhaust administrative remedies before seeking judicial relief regarding good time credits. In Berry's case, the denial of a clerical error correction motion was affirmed. Thomas Williams' convictions for firearm trafficking and possession of machine guns were affirmed. The court found sufficient evidence that he believed the firearms were for unlawful disposal based on an informant cover story and determined that Glock switches legally constitute machine guns under federal law. Darrell Thompson and Antonio Hare bank fraud conspiracy sentences were affirmed. The court rejected ineffective assistance claims regarding Armed Career Criminal Act enhancements, noting the record conclusively showed qualifying prior violent felonies. For Hare, the upward sentencing adjustments for his supervisory role were upheld. Jimmy Lee Allred petition for a writ of mandamus regarding delayed post-judgment rulings was denied as moot since the district court had already ruled on the underlying motions. Donnell Callahan compassionate release denial was affirmed because his medical issues were found to be benign and he no longer lacked care. Perry Frank Moore's supervised release revocation sentence was affirmed as procedurally and substantively reasonable given his criminal history. Moving to the Fifth Circuit, Samuel Sanford appeal was dismissed after counsel withdrew under Anders. Vicente Carrillo Ojeda illegal re-entry sentence was affirmed, with the court finding no plain error in the district court explanation or discretion in imposing an upward variance. Derek Mingert challenge to a supervised release condition requiring sex offender testing was dismissed for lack of jurisdiction because it was not ripe until he was actually subjected to the condition. In the Sixth Circuit, Justin Carroll convictions for sexual exploitation and coercion of a minor were affirmed. The court found sufficient evidence that he induced a 14-year-old victim and ruled that the victim consent is irrelevant to the offense. Cody King career offender sentence was affirmed. The court held the Sentencing Commission did not exceed its authority by using state drug convictions as predicates for enhancement. Christopher Clunt's supervised release revocation for failing to register as a sex offender was also affirmed, with the court finding his 2-week residency at an apartment satisfied the statutory definition of a primary residence despite any legal misunderstandings about registration deadlines. Finally, back in the Eighth Circuit, regime bogan RICO and felon in possession indictments were affirmed. The court held that juvenile conduct can be used as a predicate act if the defendant ratified it as an adult, rejecting arguments that the Juvenile Delinquency Act barred its use. Leonard Higgins' felon in possession conviction was upheld under binding precedent. Lance Longy failure to register as a sex offender conviction was affirmed. The court defined uncontrollable circumstances narrowly, requiring events that physically prevent compliance, which his testimony about harassment did not meet. Back to you, David.
Thanks, James. Aisha has the civil rights docket.
Thanks, David. We have 10 cases today, 9 from the 4th and 10th circuits with a single case from the 5th. The disposition mix is straightforward. All 10 were either affirmed or dismissed. Starting in the 10th circuit, we have one substantive civil rights ruling. In Webster against CHP Correctional Health Partners, the court affirmed summary judgment for the private medical claims administrator in an Eighth Amendment deliberate indifference claim. The plaintiff established the objective severity of his hip injury and treatment delays, but the 10th Circuit held he failed to prove the subjective state of mind required for liability under Section 1983 of Title 42. The record lacked evidence that any individual employee knew of and disregarded an excessive risk to the inmate health. The court also rejected arguments for systemic liability, finding that claim was waived. Moving to the 4th Circuit, we have 9 cases, 1 dismissal and 8 affirmances. The lead story here is Chapman against Hegseth and others, where the 4th Circuit dismissed an appeal involving Title VII and Age Discrimination in Employment Act claims for lack of jurisdiction. The court held that because the United States was a party, Federal Rule of Appellate Procedure 4 requires filing within 60 days. Chapman filed 35 days past that deadline without a timely extension or demonstration of delayed notice, making the appeal untimely.
A Newman against Boeing Intelligence and Analytics, the court affirmed summary judgment for the employer on race and color discrimination claims under Title VII of the Civil Rights Act of 1964. The 4th Circuit held that Guillermin forfeited her right to appellate review because her informal brief failed to challenge the basis for the district court disposition. Fisher against Moore and others was affirmed under the doctrine of cumulative finality despite a prematurely filed notice of appeal. The district court had dismissed claims against 5 judges with prejudice and claims against a clerk without prejudice, affording Fisher 30 days to amend his complaint against the clerk. In Willis against Sponseller, the court affirmed the dismissal of Section 1983 claims, finding no reversible error in the lower court's adoption of the magistrate judge recommendation. Brown against the West Virginia State Police Forensic Laboratory was dismissed under Section 1983. The 4th Circuit upheld the district court's determination that the claims were barred by 11th Amendment immunity and the doctrine established in Heck against Humphrey. Blankenship against Short saw the affirmation of orders dismissing his Section 1983 complaint without prejudice and denying his motion for reconsideration. Bethea against Bissett and others was affirmed as time barred. The court held that Bethea filed outside the applicable statute of limitations and failed to offer any argument on appeal to demonstrate error. Rounding out the docket in the 5th Circuit, Naylor against Town of Rayville and Popeye's Louisiana Kitchen was affirmed.
Reduced. The court upheld summary judgment for the franchisor, holding it is generally not liable for the acts of its franchisee employees or for securing the premises under Louisiana law. Naylor failed to provide evidence disputing this relationship. Back to you, David.
Thanks, Aisha. Let's turn to Michael for the constitutional and prisoner litigation updates.
Thanks, David. 14 cases today across the 11th and 4th circuits. The 11th Circuit issued 1 affirmance. Over in the 4th Circuit, we saw 1 affirmance, 2 dismissals, and 7 denials. Starting with the 11th Circuit, the court affirmed the dismissal of Curtis Nairn's motion for relief from judgment under Federal Rule of Civil Procedure 60I. The court held that his filing constituted an unauthorized second or successive habeas petition under Section 2254 because it relied on newly discovered evidence to assert a new claim of actual innocence, effectively attacking the merits rather than challenging the integrity of the prior proceedings. Moving to the Fourth Circuit, the court affirmed reciprocal attorney discipline against Mark Anthony Key, suspending him from practice until he is reinstated by the North Carolina State Bar for failing to file required documents in multiple cases. The court denied a writ of mandamus in Emery Childs' case as moot after the district court ruled on his underlying Section 2255 motion, and also denied Robert Christensen's petitions for a writ of mandamus regarding undue delay and the validity of his criminal judgment. In a string of habeas-related appeals, the Fourth Circuit dismissed Marcus Isaiah Curry, Michael Scott Hoover, Milton Lewis Lane Jr., and David Turner. Curry failed to obtain a certificate of appealability because his challenge essentially attacked his underlying convictions. Hoover and Lane similarly failed to make a substantial showing of the denial of a constitutional right required for a certificate of appealability. Turner's appeal was dismissed for lack of jurisdiction over non-final district court orders. The court also denied Eric Rahumid Hobbs's motion for a certificate of appealability, finding he did not meet the statutory standard for appellate review. Additionally, the court dismissed Weldon Eugene Holtzclaw Jr.'s petition for a writ of habeas corpus due to lack of jurisdiction over original writs, and dismissed Charles Terry's appeal for failing to specifically object to the magistrate judge's recommendation on ineffective assistance claims. Back to you, David.
Thanks, Michael. Maria has the business and civil law roundup.
Thanks, David. We are looking at 19 cases across 8 circuits today. The disposition roll-up is mixed: 4 reversals or remands, 2 split outcomes, and 13 affirmances or denials. I will start with the decisions that changed the lower court's result. Over in the 7th Circuit, the court reversed a denial of remand in the Abbott Laboratories preterm infant nutrition litigation. The key issue was fraudulent joinder. The appellate court held that Pennsylvania Hospital was not fraudulently joined because the plaintiffs had a colorable claim against them. The district court had improperly expanded the fraudulent joinder doctrine to look at the plaintiff's subjective intent and litigation conduct, but the 7th Circuit said that is not the standard. The case goes back to state court. Moving to the 9th Circuit, Menzies Aviation lost its bid to compel arbitration in a major employment dispute. The court found that Menzies waived its right to arbitrate by actively litigating the case for 28 months, engaging in discovery, depositions, and motion practice, before suddenly filing a motion to compel. That delay demonstrated an intent to use the federal court system rather than arbitration. Also in the 9th Circuit, Robert Edward Raya had a mixed result in his ERISA action. The court affirmed the dismissal of his 401k plan claims, finding he knowingly waived them in a separation agreement. But it reversed the summary judgment on his pension plan claims. The district court had relied on a 2008 amendment without addressing evidence that it might have been backdated to include an employee hired in 2011. In the 4th Circuit, the Department of Energy National Energy Technology Laboratory lost its summary judgment victory in a Freedom of Information Act case. The appellate court vacated and remanded because the agency failed to properly justify its redactions under the law enforcement exemptions. It did not argue on appeal that the exemptions applied to specific requests, so it could not sustain the withholding. Turning to split outcomes in other circuits, the 10th Circuit split its decision in Wildcat Coal versus Pacific Minerals. It affirmed the definition of adjoining lands but reversed the summary judgment on royalty recalculation. The court held that the lease had a clear 36-month protest provision, and because Wildcat did not protest earlier calculations, it was barred from seeking retroactive adjustments based on its new interpretation. The 6th Circuit also split in Muller-Brass versus David Crompton regarding a personal guarantee on a defaulted loan. It affirmed summary judgment but vacated the part about attorney's fees. The district court had failed to address whether those fees should be treated as part of the underlying secured debt, requiring a reallocation of settlement proceeds before enforcing the guarantee against Crompton personally. In the 11th Circuit, Michael Davis lost his toxic tort lawsuit against Lockheed Martin Corporation. The court affirmed summary judgment because the district court properly excluded his expert witnesses under Daubert. One expert relied on a weight of the evidence analysis without explaining his methodology or evaluating the Bradford Hill factors, and the other just adopted the opinions of others without an independent risk assessment. Over in the 3rd Circuit, Electo Healthcare Services won confirmation of its Subchapter 5 bankruptcy plan. The court rejected arguments that the appeal was moot and found that a contingent debt to LHP Hospital Group satisfied the eligibility requirements for small business debtor status under the law. The 5th Circuit affirmed civil contempt sanctions against Michael Lockwood in his bankruptcy case. He had knowingly disobeyed a valid injunction under his Chapter 11 plan, explicitly stated he would not comply, and waived his arguments by failing to raise them in the lower courts. In the 8th Circuit, Matthew Goforth lost his federal antitrust claims because they were compulsory counterclaims that should have been raised in an initial arbitration proceeding triggered by a non-compete enforcement action. Also in the 8th Circuit, Anthony Knight Family and Medical Leave Act claims against Cambria Company were dismissed on summary judgment. He could not show that his termination was pretextual given the evidence of a reduction in force. Back in the 10th Circuit, the Church of Jesus Christ of Latter-day Saints reversed summary judgment in its insurance coverage dispute with National Union Fire Insurance. The court found the policy definition of occurrence ambiguous regarding repeated sexual abuse by a single perpetrator. Under Utah law, ambiguity in adhesion contracts is construed in favor of coverage, so the case is remanded to determine if the church interpretation, that it created a single dangerous environment, constitutes one occurrence. Finally, we have routine affirmances and denials. In the 10th Circuit, Brian Garrett Fourth Amendment claims against Denver CARX were dismissed because police had probable cause to detain him for intoxication based on his behavior and a physical altercation, making the warrantless seizure for detoxification reasonable. In the 4th Circuit, David Graham Grice's civil action was dismissed after the court found defendants were not in default due to service defects, and Jordan Owen's motion for preliminary injunction was denied because he showed no likelihood of success on the merits or irreparable harm. That brings us to 19 cases. Back to you, David.
Thanks, Maria. Raj has the immigration and government docket.
Thanks, David. 14 cases today across 6 circuits. The disposition roll-up: 1 reversal and remand, 4 affirmed in part and reversed or dismissed in part, 2 denials of review, 3 dismissals for lack of jurisdiction, and 4 routine affirmances or denials. We start with the 4th Circuit's jurisdictional dismissal and a split affirmation reversal on a frivolous appeal deadline issue. Then we move to the 6th Circuit's immigration denial, the 7th Circuit's major remand on fraudulent joinder, the 9th Circuit's Social Security affirmance, 2 environmental and tax denials from the D.C. Circuit, and finally 5 Veterans Affairs appeals from the Federal Circuit, with 1 dismissal of a government appeal and 4 jurisdictional dismissals of veterans' claims. Back to you, David.
Okay. That is the daily rundown for Tuesday, July 28th, 2026. Subscribe or follow for the next update. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction.